Well, we're here today to talk about perspectives on the judiciary. More futuristic, forward-looking topic. Start with easy questions.
Very well.
What, in your opinion, would be the qualities of a good judge?
Trial or appellate?
Well, you can take your choice. You want to do both?
Let's start in the trial court.
Okay, trial court first. We'll work our way up.
A person, in some of these, obviously, the characteristics will apply to both. Trial judge, tremendous patience, a realization that invariably the people in front of you, both the parties and the lawyers and others, will be tense about that situation. Courtroom is where we work. The courtroom is where we are routinely, and we reach a point where we're very comfortable at it. That's not the case for everybody else. I spent more than a few years as a trial lawyer, and I have to say I got comfortable in the courtroom, but being comfortable was not enough. When you walked in that door, there's a tension because the nature of the place is that we have a legal battle going on, and it may be before the judge as a trier, it may be before a jury, but we have a legal battle going on, and you're on one side or the other of it, or you're testifying on one side or the other, or you have an interest in one side or the other. And so there is a tension, and the judge has to be a person who consciously and unconsciously realizes that the folks out there are under that strap. And as he or she makes rulings, especially rulings in which, as you have to very frequently to maintain control of that courtroom, and sometimes be very, very hard on someone who's out of line, that in that process of acting, that you do so in a way to recognize their dignity as a human being and to not go beyond what you really need in order to accomplish what you're trying to do. And so, number one, a person who's aware of that reality and who is going to respond to it. Number two, you want someone who's obviously intelligent, hopefully of high intelligence, so that they can know that which is needed, that's in terms of the law of a situation and the facts. You want someone who's had some experience with life, so that many of the situations that you face, there are decisions made that you really are making on a subconscious level. I mean, you're reacting to. You just know that that's what needs to be done.
Instinctive almost.
Instinctive indeed. And so someone then with keen instincts about it as a consequence of maybe formal education, but experience, or the combination of the two. Person who has patience with the people. That's not to say you don't move them along, but patience with the people out there as they stumble, as they are trying to do their thing and do it in a setting which is not their bailiwick, but ours.
Right.
And someone who will get after their work and stay with it and do what needs to be done.
Which I'm sure is also a quality of a good appellate judge.
Many of the things I just said overlay, of course, to the appellate judge. Now, the appellate judge doesn't have that great variety, great numbers of people who are there who are not used to being there, because we're dealing with lawyers and people who have experience with the courts. We're not dealing with witnesses. We're not dealing with jurors. We're not dealing with those who just happen in and maybe once in their lifetime. The folks we're dealing with, recognizing that there'll be lawyers who are in for the first and second and third arguments who are just starting. But these are professionals. We're dealing with professionals. And we expect more. We expect more in terms of that. But at the same time, some of the things I said before of having some understanding and some patience and so forth factors into the appellate court too, because the lawyer's standing there looking up at not one judge. The least you can be looking at 3. And sometimes you're looking at more than that. We know of in our state systems, we have Supreme Courts that are made up of 7s, made up of 9. En banc, in the Fifth Circuit, you're looking up there, if the full court is there, you're looking at 17. And if it happened to be that there was a senior judge on the panel that the case was first heard by and now en banc, you may have 18 up there.
On high, too.
Oh, mercy. I mean, you can't keep your eyes on all of them. And it's really something because you don't know where, God. You've got to remember that.
Well, I would imagine functioning on a panel must be greatly different for you then than sitting on banc with the full court.
Oh, sure. Oh, sure. On a panel, you typically are hearing a case, some few exceptions, invariably for the first time. You come in after having read the briefs. You've got some good work by your law clerks if you're fortunate enough to have, as we usually do, very able law clerks who suck the thing out for you before you go in there. And you have some idea where it's going. You may have some questions to ask. And if it has en banc, the way we do it in the Fifth Circuit, if it's being heard with oral argument, it's because somebody has some questions to ask, or it's a novel question in whole or in part. If it's an easy thing that's an open shut, we're going to deal with it without delaying it by waiting for a slot on the oral argument panel. You know, what we call the screener system. I wish they'd given it a fancier name like the expedited special system or something. When people hear summary calendar, it looks like it's the back of the hand. But as we well know, some of those summary calendar cases get a very, very careful review. It's there for oral argument because the judges have questions. So you need to be ready to answer them. Yeah, the challenge is to anticipate what is it they want to talk about. The difference between the panel decision and that the panel setting as compared with the en banc, you've had a decision by the court. The majority of the active judges of the court, for one reason or another, were not satisfied with that decision and want to see something else done with it. Maybe totally reversed, maybe modified or adjusted, maybe explained better, something. Or because of the rules that we have self-imposed, and they're very, very needed and very sensible rules, that one panel, so that we'll have a uniformity in our law, and the lawyers will be able to know what the law is so they can tell their clients in a given area. The court has spoken to this, and the court has said, and therefore you should do thus and so. I mean, that's the reality of practice of law. Or the court had not yet spoken on this issue. The closest they've come is, and my best judgment is that they'll do thus and so. Sometimes you're right, sometimes you're not right. That's all part of the wonder and joy and excitement and pain of being a lawyer. En banc, they're there, and you've got to wonder, what is it? Sometimes we'll tell you, we'd like you to brief this issue or focus on this particular issue. Sometimes we don't. I think we ought to try to do more of the former than the latter so the lawyers would have a feel for it. And
was it Judge Rubin who did that?
Oh, yeah.
Routinely
Judge
issued
Rubin was
an issue.
Very good about that. Suggesting to the lawyers that as part of their argument, they focus on, or ask them to maybe write a little bit more in their brief about that subject, and which was one of the reasons why he was just one of the top judges I ever knew.
That actually is my next question. Who was one of your favorite judges that you admired most or admire?
Alvin Rubin, John Minor Wisdom, just immediately come to mind. Just quality judges, and every way you want to measure a judge. All of the things: intelligence, preparation, heart, experience. They knew what they were dealing with, reached out invariably beyond the party or parties that were in the court, and they had a feel for that. Just the kind of folks that you really hope every judge would be like. You know, they can't be because they were exceptional, but
yes,
easily.
They were. Let's talk a minute about the qualities of a good lawyer, and I'm going to change the question a little bit, not just the qualities, but what do you think the role is of a lawyer in today's society? Obviously, I think times have changed, lawyers have changed as a breed in some ways, and maybe lawyers could do a little bit more today of the things they did yesterday in terms of community assistance. But correct me if I'm wrong there. What do you think the role is of a good lawyer, and what are the qualities that they have?
Of course, this is a highly personal thing, and I'm sure that people will disagree with me. I happen to think that lawyering is the ultimate profession. The ultimate profession. Do you place it above medicine? Yes. Do you place it above the religious? Yes. And they said, well, that's pretty, wow.
You're going to have to explain
Yeah,
that.
hell, what are you doing? Profession is not a business. What's a business? I define a business stripped essentially as it's a way to make a living, a way to make money. Period. And you structure it in such a way that you can make the most money in the simplest amount of time and investment of time and other things of assets of value and so forth. Profession translates into a service. A profession gives more than it gets. A profession has a responsibility that goes out beyond any business. And law has traditionally been a profession. And lawyers have been traditionally called professionals. What's the biggest change that I've seen in the 40 plus years? It's now 42 plus since I've been a lawyer. The movement away from being a profession to being more and more of a business. I see as you know, I see the glass half full. It's a plus and a minus, I guess. But I see the glass half full. I see the movement coming back. Maybe it's just hope, but I see the movement coming back and the realization that we just went too far in the last three decades in terms of profession, in terms of what can one make doing this. And back to what the lawyering really is. What is lawyering? Okay. Solving the problem of your client that the client brings in. The client brings in the problem, they've got a problem. They want to find out about title to property. They've got a contractual dispute. They've got a problem with the neighbor about a fence. They've got you fill it in, or a criminal matter. I've got a problem. I've got a problem with society. That's typically criminal, not always. I've got a problem with an individual. What do I do, lawyer? And the lawyer says, let me see. Okay, this is what you need to do to straighten this out. This is how we need to resolve this dispute, resolve this quandary, this problem. But it doesn't end there, because the essence of that lawyer is to be consciously and unconsciously aware of what I do with this has got to factor into what's best for society. What's best for society.
Beyond the immediate question.
Society? Your society that you're in. What society are we in? Well, of course we're in our society, in our own community. Is it more? Oh, yes. And in terms of our breakdown of things and units, we've got the city, the parish or county, and the other 49 states. We've got the state, that's society, what's best for the people of the state. We've got the United States, the country. And now we go beyond that to the world. What's best for mankind in this setting? Lawyers address themselves to that, consciously and unconsciously. Lawyers have traditionally been dealing with that. And that's why I say the legal profession is the profession. Why? Because I'm a lawyer? Yes. No. Put that aside. Because it's the reality of it. Look at the folks who are mostly responsible for the success of this country from the very beginning. And say, what were they? What were they? Like as not. They may not be making their money as lawyers. They were legal trained. Happenstance? Oh, that's not happenstance. That's not happenstance at all. It's the reality that they were people who would give thought to what is best for them. Oh, yes, we can resolve this dispute this way. We can resolve this problem this way. What's best for society? What's best for society? Lawyers. Lawyers. Nobody else. Not the people who practice medicine, not the people who are fixing cars, not the people who have all the commercial activities, not any of the others have this press in terms of what's expected of you. That's the professional side of lawyering now. That has not been and is not what's driving the business side of lawyering that we've had so much of in these last two or three decades. But as I said, I see the glass half full, and we're moving back to the other. And I think
do you have any ideas on ways we could implement that or foster along the idea of lawyers becoming professionals again?
It's got to start before they ever take their oath. It's got to be a major consideration in law schools. It was when I was in law school in the mid-50s. I went to service in 51 and got out in January of 55, and I went to college and then went to law school in the latter part of the 50s, graduating in January of 59. In the law school then, we had formal courses on it, by whatever title. But what they were teaching us was the responsibility of lawyers that go out beyond resolving this little dispute and knowing the law as to a title defect and knowing the law as to how this lawsuit should be tried and won. But lawyering and the dimensions of lawyering, the responsibility out beyond your client, out to the totality. And as time has worn on, law has become more and more complex, and there have been so many more things you had to learn, that you had to memorize, you had to know the answers to, and so on, that it cut into the other, perhaps. Maybe that's part of it. I'm not looking for excuses. I'm looking for reasons why some of the courses that were mandatory when I went to law school and for the decade or so afterwards are just not there. And if they're there, invariably they're optional.
The concrete has overpowered the abstract in some ways, and unfortunately. Talk for a moment about what it was like to be the chief judge and what characteristics served you well as the chief judge of the Fifth Circuit.
Patience. Really enjoyed it, I have to say that. There were a number of things that I would rather not have had to do necessarily, because under the statute, amongst other duties, any complaint against any judge, it might be on judges actually, that would staffs too, but any complaint against any judge goes to the chief judge.
Right.
And the chief judge is charged with making an prompt investigation into it to see whether or not there's any merit to this, and if not, dispose of it. And most are. Misunderstandings and momentary lapse and that sort of thing. But every now and then it wasn't so, and you had to look a little further. And sometimes you had to do more than look a little further. Sometimes under the statute, you had to appoint an investigative committee composed of an equal number of trial and appellate judges, plus the chief. Always the chief gets saddled with it, and have hearings and bring the witnesses in and bring the records in or whatever's needed in order to make a decision as to whether or not the complaint against the judge had some validity. And if it did, you had to take it to the council and make a recommendation. That committee did. We have this complaint. This is what we found. Here's what the evidence is. Here's our record before us. Here's what the witnesses told us. Here's what else was put in the record. And here's the recommendation we're making, that we dispose of it this way. And then the council decide by majority. The council being composed in our circuit of an equal number of trial and the district and set of court of appeal judges, trial and appellate judges, plus of course the chief. 9 and 9, plus the chief. And then the council rules, and if the judge is unhappy with the result under the statute, you go to the national level and ask the judicial conference. And the judicial conference is composed of the chief judge of each of the circuits, the 13 circuits, because we throw in a couple that are not numbered. And each circuit, except those that don't have district judges, has a district judge representative selected by the judges of that circuit. So and the chief justice. So the total 27 judges sitting around that table. That's the judicial conference, and they meet twice a year, March and September. In between meetings of the council, there's an executive committee appointed by the chief justice that has the responsibilities and the powers of the conference. Go to the conference. The conference has decided that when there is such an appeal of a judicial council's action on a complaint against a judge, that a special committee appointed by the chief justice will hear the matter and act for the council. I serve on that committee. after I had served on another committee dealing with ethics of law of the judges for years. When that council acts, end of story. That's the council's action on that, and that is the position of the courts on this particular complaint against this judge. Been challenged. Matter of fact, it was challenged in a case that came up a lot of our circuit when I was chief judge, and the court upheld the validity of it at circuit level, and we still have to hear what the Supremes are going to say if indeed they ever grant a writ on it.
It's interesting that as chief judge, you would have addressed this head on, when prior to even being a judge, you were the strongest advocate of, or one of the strongest advocates of peer review for attorneys and professionals generally. And maybe that ties in, you can explain to me whether you see it this way, with the idea of attorneys being professionals again, that we need to check ourselves. And maybe at the law school level and perhaps a mentoring system, if we could do that.
Conceptually, I spent, as you know, before I came on the court, I was on the committee on, what was it, codes of conduct at one time, the committee on professional responsibility at another when we changed it.
The Louisiana Supreme Court.
Yeah, a committee appointed by the Louisiana Supreme Court, composed of, seven or nine, but judges, lawyers. And it was their responsibility to receive the complaints against lawyers. And I did that for 7 years. And before the court moved me from the committee that reviewed complaints against lawyers to the committee which reviewed complaints against state judges. And I did that for the Judiciary Commission. I did that for a brief period of time. It was only a year or so before I came on the federal bench. And then got on the federal bench, and the chief said, well, you've had your period of this other. So whap! So then all of a sudden I'm on the committee for ethics for lawyers, and then whap on the committee for ethics for judges on the federal side. So I've done them on both sides. Peer review is critical. Who best should know what a lawyer is doing right, but others who have walked that same course is a question one might ask. And my answer is, damn few are in a better position to. We use the jury system because we say we want a person who has been challenged, if it's a criminal matter, in terms of his or her conduct, or a person, people who have a dispute civil matter in a civil case. We want a jury of their peers. We want people who are walking that road like that to decide what the answer is. Okay, that same concept spins over here. Who best should know whether something is ethically acceptable, professionally acceptable, whether it be an action by a judge or an action by or a lawyer? Then those who are walking that same road, God Almighty, I don't have any problem with that. I know that people who think differently, but I have to tell you, I believe it down to the bottom of my heart, and I'll just stand against anybody who says there ain't nothing to that. I said, yuck, it ain't nothing to that. You hadn't thought this through. You want to have some doctors determine whether a lawyer's doing right. You want to have some lawyers determine whether a doctor's doing right. So, well, yeah, we have lawyers determining whether doctors do right all the time. No, we have lawyers and judges and juries decide whether what a professional did in terms of professional's performance and hurt someone or was allegedly hurt someone, whether they acted within what we consider the proper grounds. That's different. That's different from saying, did you act professionally within that which is the reaches of what you are accountable for and responsible for. That's a different horse. So peer review, that's critical, it seems to me.
That's interesting you brought up the concept of the jury. Having grown up and studied and practiced law in Louisiana with our mixed heritage of civilian law and common law, choosing between the three systems, meaning pure civilian, pure common law, or a mixture, as we have here in Puerto Rico and a few other select places. What do you think is the better of the systems?
You'd have to say I'm disqualified because I'm in this system that's mixed. I don't have any hesitancy on that. Mixed. There's some things that are best decided by the judge. Just simply so. Best decided by the judge. I can get off into these other things. There's some things that really call into play a decision by the peers of the people who are in front of you. Did they act responsibly? Did they act negligent? Under these circumstances, with these pressures, with these influences, what's that? People, they walk in that. Let them say to us. And so best for the, but then there are things that need both. And we have them where we...
What sorts of things do you think are better for a judge to decide besides a pure legal issue?
The pure legal issues, obviously.
Mm-hmm.
And then sometimes you have a factual thing which is slap open and shut, but has in it a factor that unless you really put your mind to it, it's going to pull you off in another direction because of an instinct, because of... I think in terms of a recent case where there's no question but the person was slapped guilty, committed a heinous crime, just period. But in the process, there was something which we also put great weight in and say what we need happens to be the assistance of counsel. And you're right to say, I don't want this lawyer. I want someone else. Or I want to represent myself.
Is this the case of the defendant whose attorney fell asleep?
That kind of thing. That kind of attorney fall asleep. Or someone making it very plain that they don't want this particular lawyer because the lawyer wants to use a defense that they don't want used. And it's in their best interest. The lawyer is doing that, which the lawyer said, listen, all things considered, this is what we've got to do for your best interest. And the guy says, I don't want to do that. And we say, well, you've got the right to be a fool and represent yourself. And that right is... You have that, and what would a jury say? Well, is he guilty? Yes, he's guilty. Let's get on to something else. And so there's a type of situation where you say, wait a minute, let's have someone who would look at this and say, the system is involved here now. And if we're going to protect the rule that, if we really mean it, that you're entitled to counsel, but you're entitled to counsel if you don't choose him, or give you one if you can't afford one. And you're entitled to represent yourself if you don't want counsel. And we've had people in everything from minor cases right up to capital cases where they just insist on representing themselves. And what the court will do is say, very well, I'm going to appoint a lawyer and he's going to sit in that chair. And if you ever want to turn to him, you're free to do so. And to tell you, to help you in a decision. But you go ahead and represent yourself.
You satisfy all the constitutional issues there, don't you?
Yeah.
Turn to for a minute to becoming a part of and taking part on the court, some of which you've addressed already. Let me ask you, what are your thoughts about the process for appointing judges and the life tenure for federal judges?
I think life tenure is very important. Election, once upon a time, and I have to say, I thought differently at one time. Let the people elect the judges. The problem with letting the people elect the judges is the lawyers have got to run, they've got to raise the money for a campaign, and it gets to be where they just slap out of reach. And there are many, many, many people who are really qualified, who would make excellent judges, who simply don't have the money or can't raise the money or won't run the risk of getting in terrible debt in order to win election. And the more I've thought about it, the more I'm convinced that an appointment process is preferable. Now, is it preferable that they be appointed for a term? We could deal with that and say, could have, as long as the term's long enough to where you have a chance to really see if a person is doing the job, and that the person would be eligible for reappointment. If they're blowing it, I could accept term for life, kind of like that. Pluses, yes. Minuses, yes. Of course. Now, how do you minimize the minuses? You minimize the minuses by the selection process, and the selection process is critically important. And one of the, I have to say it, the great weaknesses in our federal system is that a selection process is totally tied to the political.
To the politics.
All the politics of it. Absolutely.
So if you were to contrast President Carter's merit selection program to
and I'm, of course,
afterward.
I'm disqualified because that's how I was played, because you picked up quality.
He sure did.
But the reality of what President Carter, who didn't like lawyers, I don't think he liked lawyers.
No, I think you're right. He did not like lawyers.
He was, because he went to the academy. Academy graduates and engineers don't like lawyers. We know that. That's all part of the way. He liked Judge Bell, and I know a few other lawyers. And his instructions to Judge Bell, as I understand it, was, I want you to set up across the country, by whatever title, lay and lawyer groups who will make a recommendation of 4 or 5 names to me for every federal vacancy. I want them to do the interviewing and whatever else they want to do to examine into people's background and so forth, and then send me their names. And I think he used either 4 or 5 as his criteria for each vacancy. And it was called the Merit Selection Commissions. And from where I sit, it worked very, very well. I'll excuse myself, because I know they picked me too. Excuse myself. They could make one mistake. But I look at the people that they picked. They picked Alvin Rubin. No kidding. First time the Merit Selection Committee worked in the Fifth Circuit, they were charged to fill the slot created by John Minor Wisdom taking senior status back in 1956 or 7. No, 76 or 7. 76 or 7. Or early 78. The Merit Selection Committee got together and boom, sent the names up, and Rubin was on the list, and Rubin was selected by the president. Then the Congress added a number of judges, 11 to be exact, to the then 15-judge Fifth Circuit, and that Merit Selection Committee, there were 2 for the Western, for the Fifth Circuit at that time, the Eastern Fifth Circuit Merit Selection Committee and the Western Fifth Circuit Merit Selection Committee, and they made their recommendations for these slots, and they were filled, and quality people, myself aside, quality people. My goodness, I looked at the folks that commission came up with, and every one of them had a background that was just impeccable, and experience. You know, we got Tom Reevely, who'd been on the Texas Supreme Court and other posts. Sam Johnson, who'd been a trial judge, a court of appeal judge, and on the Texas Supreme Court, and a prosecutor before that. And Jerry Williams, who was teaching there at the law school for 30-some-odd years at Texas Law School, he was just an excellent judge. And Albert Tate, Lord have mercy alive, how could you find a judge? And you asked me a while ago, I should have said Alvin Rubin and John Minor Wisdom and Albert Tate, the 3 finest judges that come to my mind that I've ever known.
Do you think any of those would not have been appointed to a federal judgeship had it not?
Oh, we know what Wisdom was, and we know that Rubin was because he had been appointed to the district bench.
Okay.
So
under the regular process, it's just
he made
anyone's guess.
Yeah,
I guess.
Now, of course, Tate, all of Tate's prior experience to come in on the Fifth Circuit he'd been a court of appeal judge in the state system, and he'd been on the Louisiana Supreme Court. He might well have made it too. He might well have made it. He should have. He should have.
He did a good job when he was here.
Oh, golly. No question.
Well, a lot happened when President Carter was the president. You had the merit selection, which he instituted for judges, to select judges. Also, we had quite a few slots filled by him on this court.
The most of any president since the beginning of time.
Right.
Because
And he was not a
Congress-
lawyer, by the way. President Carter.
That's right, President Carter. And he had the most slots to fill because Congress expanded the federal judiciary.
Right.
They added 35 appellate judges, licked one fell swoop, and they added a whole bunch of district judges because the workload had just gone up and up and up, and they finally got around to addressing that.
Right.
But he didn't make any appointments to the Supreme Court. He didn't
No.
get appointed by the Supreme Court in his.
But then President Carter split the circuit, correct?
And when he was president, they split the. Yes.
I've read that the former Fifth Circuit, prior to the split, with 26 perhaps filled slots, maybe it was 25, as you told me.
Yeah, but never got around to
We
that
don't know.
26.
But it was the largest court in the world.
Yes.
Single court
Yes.
body.
Yes.
It's amazing.
Mm.
Contrast that court to this court in terms of workload and procedure, how things have changed from,
Oh, golly.
from
Workload.
then to now.
Let's take workload. You talk about a difference.
Favorite subject.
1978, Congress looked at the workload of the Fifth Circuit and said 15 judges shouldn't be charged with handling that many appeals. And Congress, in his wisdom, said, look here now. We've got to give them some additional judges. 15 can't handle that load properly, and knowing that they give the time they need to it and not having to work 18 hours a day, 7 days a week, and so on, and so on, and so on. 26 judges are needed to take that workload. In 1978, we had 3,800 appeals. Okay? In 2000, the year ending in June 30th of 2001.
Okay.
We had, for the 17 judges, and we got 3 vacancies, 14 judges, 8,700 appeals. Ha, ha, ha.
Well, what is the answer to that, though? If the goal in expanding the number of slots and in splitting the circuit was to allow appellate court judges to have the time to address these issues and these cases in the way they should be, what's the answer today? Because it's certainly, 3 times worse.
No question about that. It's not, the numbers will get misleading. So many of those are really easy appeals. So many of those are pro se appeals. So many of those are appeals of just sentences. The average case back in 1979 when I came on the court typically was a case that had some serious legal issues in it that you had to struggle with. It was nice to get an occasional case that had not just quarreling about their sentence or something easy. And you could look at it quickly and decide what the resolution of it was. In addition to that, Congress, and it's a very understandable political thing, if you have a sentiment out there about we've got to do something about this, there ought to be a law. You ever hear that? Mm-hmm. Ought to be a law. Well, they did that. They recognized those demands that there be laws, and they passed laws. There was one set of legislation here, and I can't tell you the year. Shame on me for that. They created 50-some-odd new federal crimes in one set of bills, including several that were death penalty cases. Now, death penalty case slows everything down. You got to be awfully careful. I mean, gee, this is not somebody who failed to pay their taxes. But Congress has done that in creating more and more and more federal offenses, things that were simply state offenses before. Car hijacking. This is just to reach out and grab one. That's a state offense. And so the states take care of that. And we'll take care of the federal level things that are peculiarly federal. Things that are peculiarly federal, people will complain bitterly about this kind of conduct which they were frightened by or angered by or a combination of both, and said, Congress, do something about that. And so they passed federal laws. And so what happens? That means then those things have got to come into the federal court system.
With the right to a direct appeal.
Oh, gosh, with the right, always direct appeal and coming up in court. And so that's what's happened to us.
Do you think there's been an increase in filings generally also, or do you think it's more a reflection of the increase in the laws and the possibilities for the Article III judge?
Combination.
Combination.
It's a combination of both. It's more filings because there are more things that now may be filed in federal court. But there are also more filings in a kind of given area. Although I've seen there's been a fall off in a number of ways. I think of when I first came on the court, Fifth Circuit was noted for a number of things, not the least of which was its handling of major admiralty cases. I haven't had an admiralty case in several years. He said, well, what? I said, we're still in the same place. We're out on the Gulf, and we got all the ships coming in. So things change, and that's the nature of the beast we're dealing with.
Have visiting judges helped much to lighten the load?
Visiting judges have been critical, and people have thoughts about visiting judges, the pluses, visiting judges, the minuses. As a chief judge, in a sense, visiting judges are a plus. You occasionally have someone that you would prefer not to have had, but that's a rarity. And if without visiting judges, how many visiting judges did we think we had last year? I bet you we had 30. Now that's visiting from both the trial level coming up and helping us, and coming from another circuit. I bet you we had 30 judges sitting with us last year.
When you have a judge that visits, or when you've gone to visit, do you find that it helps in unifying or creating a more uniform law across the country?
I think there's a plus in that. I've sat now, in the short period of time I've been a senior judge, with the 9th and 10th and 11th, and multiple times with each. There's a plus in my hearing the cases in these other jurisdictions and hearing the judges' reactions to it, and the reverse, them hearing my reaction to it. And maybe because we've handled it, or maybe not, but there's a plus in that. One of the biggest pluses is what we would like to have is the federal law ought to be the federal law, and it ought to be, quote, uniform across the country. We know that that's more hope than reality.
Right. There's too much room for interpretation of the federal law.
Oh, yeah. And, of course, one of the things, the Supreme Court, one of the reasons they'll grant a writ, they feel pushed to grant a writ, is because you got one circuit saying one thing and one circuit saying another about the same rule of law, and we can't have that. And so they're forced to have to take that case, and give them some work. But they address that by saying, how did they? I'm having to reach back and I can't pull it up. Wasn't a rule. I think it was just an urging by the Supreme Court. Please, before you create a conflict with another circuit,
think twice.
Pass it around to all of the other judges in your
you're
circuit.
Kidding.
Yeah.
So I guess the visiting judge is today's version of the circuit rider.
Absolutely.
They really get around.
Absolutely. Yeah. And that's a real plus, and I've enjoyed sitting in the other
I would
circuit.
imagine so. And what's been the hardest thing for you as a federal judge? The hardest thing you've had to deal with or do or found the most difficult?
Oh, God, that's easy.
Is it? Okay.
Oh, death penalty cases.
Okay.
I'm absolutely opposed to the death penalty. But I took an oath to support the Constitution. Therefore, I have to support the death penalty when I think it's a wrong, stupid, god-darn thing. My goodness, what are we doing? We're saying to this person, you have committed the unpardonable. And for that, you're going to get the death penalty. What did that person do? They took a life. So we calmly, objectively, and in the name of justice, we take a life. Something wrong with that. So I'm opposed to the death penalty. So that aside, I don't mean I wouldn't want to go out there and throttle those SOBs myself that do these terrible things. That aside, it's a question of your society reacting to it. What do your society do about this? And so I'm against it. But we have these cases, and we have to look at them, and look at them in terms of the law, and look at them in terms of what occurred here, and was it a fair trial, and so on. But keep out of your mind that I'm against this, and do it, and then write an opinion and sign on in which you affirm. Hardest part.
Do you think criminal defendants today are getting fair trials for the most part?
Oh, yes. I think so.
How do you feel about sentencing today?
In part fine, in part out of hand. Again, the political process reacts to the pressures. When people are upset about something, they say make it a crime. When they continue to be more upset about it, make the punishment more severe. When they continue to be upset about it because they aren't getting to be less and less, and they're not winning that particular battle. Make the penalty life. Look how many offenses we now have, as against 20 years ago, that the offense is mandatory life. State and federal. State and federal. Mandatory life. But if that isn't stupid, absolutely stupid, because you think, what, it's free? And our people are slowly waking up, slowly waking up. No, it's not free to put somebody in jail. It's costing tens of thousands of dollars. It's up to 30, I suspect now, for the recurring cost each year.
Right.
And $60,000 or $70,000 to make a place for them. And so, wait a minute. This is costing. We're spending more on jails than we're spending on schools. Well, let's think about this.
Wow.
How many of those people in there don't really need to be in there? Well, I guess a lot of them. Why are they in there? Because it says right there in the statute that they got to go for life. And,
no exceptions.
And no parole and no pardon and so on. So, yes.
Should some of that money be diverted to rehabilitation rather
Absolutely.
than...
Absolutely. 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 If the concept of jail was punishment, rehabilitation.
And deterrence.
Punishment, rehabilitation. The punishment would be the deterrence, and then the rehabilitation, when you get back out, we're going to reduce the likelihood that you're going to do it again or something like it.
And that's where we're not doing all we could.
We have some that we can look at with pride. We can say, hey, that's really working, and then we can. Majority of the situations, no, not so. And this has been going on for years. I've been talking about this for 30 years before I ever became a judge, saying, what are we doing? What are we doing? And putting people away. Well, we tough on crime. Oh, boy, I'm tough on crime. We ain't going to have that.
After the fact.
Yeah,
only after the fact.
After the fact.
Let's turn to your opinions. Things you've dealt with specifically. Which of your opinions are you the most proud?
Oh, gosh. I wish I could tell you. I've enjoyed some opinions. I've enjoyed some that are just strictly legal, and you look at them and people get all excited about them for different reasons, like redistricting cases. I think of a couple we had that are highly publicized, but you get in them and you get the facts in front of you and you get the law in front of you and then you apply it and you do what has to be done. I think of one this goes back close to 20 years, I guess. Back in the early 80s, we had a Congress ordered redistricting. Now, every 10 years you have to have redistricting. But when you get the results of the census, each decade census, you got to look to see what your situation is, and you've got each state. We determine how many representatives they're going to have because we take 400 and how many, 24 or something. Shame on both of us.
Yes, shame on
in
both
the House,
of us.
and we divide the number of places in the House of Representatives and say, well, they're going to have X representatives, and we look at the states, and you get 12, you get 7, you get 6. How it divides out. And when a state gets more or less than they had, they've obviously got to redraw their lines. And sometimes even if they have the same number that they had, because of other legislation that's come down the pike about the fairness of the makeup, so that you don't have an overabundance of one race or what a creed or whatever. And but usually it was a racial thing. And certainly in our part of the country it was a racial thing. And so you would draw the lines in such a way that you could either exclude would not allow a majority of a race that you didn't want to have a majority or a large number, or sometimes the reverse. But drawing those lines and then and Congress got in the mix and passed legislation, and of course the Supreme Court's got in the mix and it's had its rules and its rulings. And so the states would do that thing, and I remember one, and in order for Congress to show how serious they wanted challenges to be considered, provided that if there was a challenge to the redistricting, it wasn't heard by a single judge. A single federal judge didn't deal with that. It had to be a three-judge court, three-judge trial court. That's a rarity now, three-judge trial court. And the chief judge of the circuit would appoint 2 district judges and 1 circuit judge to go. And in the early 70s, I remember the chief called me and said, "You want to take on this responsibility?" I said, "Heck yes, man. Trial level is a whole lot better. I was a trial lawyer. It's a whole lot more fun in the trial court than it is in the court of appeal, the dull court of appeal." And so we had a redistricting case down in South Louisiana, in New Orleans, as a matter of fact, Orleans Parish. And when we looked at what they had drawn, and they had the face of a duck up there. You couldn't help but see it. It had a beak and all.
They had to be faithful to their heritage.
Yeah, and so the three-judge court, we had a hearing it was a week's hearing. It really was thorough and well represented, good lawyers on both sides, and presented the case, all the evidence, and then gave us the law. And the panels, we meditated on it hard. We were unanimous in our decision, and I remember I wrote an opinion for the panel in which we ordered the state to re-examine what they'd done and to redistrict Orleans Parish consistent with a couple of federal statutes and so on, consistent with the law. And we gave them a deadline. Said, "We anticipate that you'll have this done by, and if not, then we will reconvene this court, and we'll draw some lines. We wanted them to draw their own lines."
Right.
Yeah, we get. Okay. So the wonderful postscript to this story is we gave the legislation until I think the early part of end of January, maybe December. The governor called a special session. They got their business together. They redistricted consistent with the law. They knew what the law was. They would redistrict consistent with the law, and absolutely it passed muster when we examined. And I got a note from my friend who was attorney for the governor saying, "We haven't met consistent with the court's directive, and we redistricts." And he said, "While we were here, we thought we'd raise your taxes. Merry Christmas." And yeah, just when they raised our income taxes by a few cents. God dog.
They had to get that last word in.
Had to get that last word in.
Well, I'm sure the Duckville case was a lengthy one. Who taught you to write? From whom did you learn the most and learn to craft opinions the way that you can today?
In terms of writing, I guess one person primarily, with a second person factoring in as well. My English teacher in high school was a wonderful lady named Elmina Thibault, Thibaut, Miss Elmina. And she taught us English and literature. And she made us write every week. We had to write whatever. She'd give us the subject matter, whatever. And you got 2 grades on it. One was content. She'd grade you on content, A through F, and a slash. And then she'd grade you on your grammar. And I got many an A/F, because if you had 1 comma blunder, I was F. Oh. She is tough. She was so damn wonderful. And she would tell us, don't waste words. Say what you've got to say, and say it clearly, and say it succinctly, and so on. And she'd make us write and rewrite and write and rewrite and write and rewrite. And she'd had a tremendous impact on my writing, my attitude toward writing, and taught me a great deal. I think she's the one former teacher that I have behind my desk in a picture. You can't see her because she's covered by books, but she's right in the middle back there.
As she should be covered by books.
And she's covered by books. God dog. And stacked them up in front of Miss Thibault.
And there was a second person?
Mr. Rebouche. And that's Rebouche with the accent aigu. You know an accent aigu versus accent grave?
One goes this way and one goes that way, right?
Aigu come this way, and grave go that way. He was an agriculture teacher, and the agriculture teacher was responsible for the Future Farmers of America organization. And the Future Farmers of America, in addition, we thought we just going to do agriculture things. Man, public speaking, he taught us that. Robert's Rules of Order, debate, all of those things like, he factored all of that in writing. And so he he had an impact as well on my. This was in those last 3 years of high school, right, when you really are subject to have an impact on you for the rest of your life.
While on the court, from a societal standpoint, what issue do you think this court was faced with that was the most important?
Oh, there's no question about that. Once the Supreme Court decided Brown versus Topeka Board of Education in 1954, and then in 1955, heck, I'm just getting out of the service, and they handed the implementation decree down. What the Supreme Court did was punt to the courts of appeals to now implement this question about we're going to have this fair treatment of the races and in all of these matters in district and in schools and in integration of the school and on and on and on. And so, no question about the most important societal impact that the Fifth Circuit has had in the last 40 some odd years, has been that took the lead in that problem of looking to see how society was treating the various segments of society, how we were treating those who were in minority, how we were treating races, how we were treating ethnic backgrounds. And we were in many places treating them fairly, many places not treating them fairly. Well, look at the South. We had separate schools. We had schools for blacks and schools for whites, period. Like as if that's the way it is, buddy. And you could be living next door to a school, but you had to go 3 miles across town because that school next to you was a white school or a black school, and you were the opposite, and you neighborhood schools, right? And it fell to the Fifth Circuit then to deal with that and to put it into specifics and the reality and many other things that dealt with society being fair to all of its members and treating with even-handedly all of its members. No small deal. We have, right today, we still have problems of that kind. Much modified, and largely modified by virtue of the decisions that were made by the members of this court from 56 on into the 80s. No question about it.
What do you expect will be the biggest issue for the court to face in the near future, or say over the next quarter to half century?
Well, that's a good question, lawyer. What do you think is going to be the biggest issue from where you sit that we're going to be taking to the court, increasingly, with the recognition that increasingly our people have been taking more and more issues that traditionally we've not considered truly legal or justiciable issues to the court and ask, what do we do about this? So with that in mind, what do you see out there in society that's going to be causing pain and problems and distress that folks are going to want to take to the courts? That's an awfully good question.
Well, if you think broadly, civil rights was serious, far-reaching, broad-based issue. What do we have in our lives today that is that way? There's a huge disparity in the haves and have-nots in this country. There's the issue of drugs, the selling of drugs. Should they be legalized?
Whether what you've just said about drugs, about the single most serious quote thing out there is drugs. And when we hear these tales, wasn't that many years ago when somebody would have said it, and said, "You're daydreaming. We've got drugs in grammar school. Get out of here. We got drugs in grammar school. We have. We've got drugs in our schools.
Drugs and guns.
Just across the country. Not just in the big cities where we thought it was going to be, some would suggest it was going to be restricted. Going to be New York and Chicago and Los Angeles and probably New Orleans. But surely not Napoleonville and Benton and not the Speaker's report. But it is. And it's harming our people to the point of, yay. Now, will it be the courts that are going to have to deal? One wonders how we can do any more than we're doing. We made it a crime. They bring it to us. We increase the punishments, in part because the legislation requires it, in part because the distress of the courts and saying we're going to. But we so seldom ever get in front of us the ones who are really, really making the money on it. We get the poor SOBs who somewhere in the middle chain or lower, or the users. That is no way to stop the drug traffic. You get the users and those who are at that level, the ones up at the top who are making the real money. And government stepping in and really doing something to see about stopping it coming into the country. Now, tremendous efforts are being made. You don't hear a great deal about it, but tremendous efforts are being made to, in some way, stop that movement of drugs by ship, for example, into the country. But they keep coming in every day, every day, every day, every day. And a person can, what are you going to do with somebody who will work a whole year and make $2,000? I'm making up figures. And come one time with something in their pocket and make 10
in an hour.
Yeah, and doing that just till you take this off the ship and bring it to this guy.
Should we legalize it?
The great debate that went on about liquor was to make it a crime, and we had all of what went with alcohol being the use of it and distribution of it being a crime. And we stopped that by legalizing alcohol. Did we? The strong argument made was, well, we'll do away with the criminal element. If you can have a store on the corner selling it, you don't have to go and be dealing with those who are breaking the law and are involved with it. And some of my people, you see, that said the Italians were doing that. I don't know. Probably a few of them, Al Capone and a few of them.
Were you on a sugar plantation?
Conducive. Plantation is the next. That's a big word. We had 160 acres. I wish I knew, not an easy answer, I wish I knew an answer to the problem. Additional effective enforcement, yes. But where do we draw the line on that? We want to lock up 2 million people? How about just 500,000 people? How about just 100,000 people? What do we do to meaningfully address this problem? I wish I was smart enough to say I know a simple answer. I wish I was smart enough to say I knew a complicated answer, and I don't.
When you look at some of the laws that have been passed over the past, say, quarter of a century, are there any that come to mind that you say were particularly wise, and are there any that come to mind that you think were particularly unwise?
Well, unwise, outlawing alcoholic beverages, because it didn't work. Particularly wise, gosh, I'm sure there's been a lot of good legislation that's been passed in terms of what's for the betterment of society. That's what Congress and the legislatures are supposed to be doing. They're supposed to be looking out over the horizon and seeing situations that are out there and saying, how do we address this and how can we improve this by either permitting or forbidding certain conduct or requiring certain action or inaction. And legislatures in our 50 states and our federal legislature, also known as the Congress, are supposedly doing that every day. I don't know that I could reach out and say which is the one that should or shouldn't have been.
Well, I suspect some of the most the ones with most impact related to civil rights and voting rights and legislation that promoted constitutional rights. So I'm not sure if it's really legislation or constitutional interpretation.
Well, it's been a combination of both, and sometimes the legislature took the lead, and sometimes the Supreme Court took the lead, and one could make a whale of an argument about which has been most important, and it's obviously both very important in this equation. Ultimately, the responsibility for there being a government in both in its performance as well as its structuring. It's with the Supreme Court. And whether the framers intended that or not, one could have a whale of an argument. An activist Supreme Court. Wow, did they really mean to have an activist Supreme Court? How do you define activist? So, is an activist if they take the Constitution and they take a fact situation that's brought before them and they look at the Constitution and they say the Constitution permits that or the Constitution forbids that? That's activist? Or is that simply doing what they took an oath to do? And I don't know of any Supreme Courts that have gone out there and hustled business. Cases were brought to them. That they reached beyond what they needed to and in a case and said more than they needed to, yeah, sure. Done that more than a few times. Has it been done at the circuit level? Of course. It's been done that way. Sometimes it's pure and obvious dicta, and sometimes more skillfully weeded into where it looks like it might be part of the decision, so that they have to follow it. But yes, is that wrong? Nice debate. One can say you're not supposed to legislate, you're supposed to enforce the laws and interpret the Constitution. And so we quite agree with that. And but, and it's always that but.
But it's a matter of how you view the Constitution and how it works.
Yes.
In the system.
Yes.
What is your view on the Constitution today? How does
it's a living document. The Constitution is a living document, and it's got to be viewed in light of today, and that's contrary to what those who would argue the Constitution was written in what year was it? 89. 1789, and that's when it's got to be. And I said, yes, okay. What did the Constitution tell me about radar? What did the Constitution tell me about AIDS? What did the Constitution tell me about? And you can fill in that blank with 100 things that they couldn't think about or talk about or anticipate or provide for because it wasn't in their mind. It just wasn't there. Or did they create an instrument, as some argued in that first 20 years, that was you could only do the things that the guys and gals, well, there were no gals.
No
gals in there. We wouldn't let gals have a vote then. That's why the Constitution is such a marvelous instrument, you see. And we've been wise enough to have an amendment process. And that's also part of the strength of the Constitution. But you got to remember now how imperfect the Constitution was, because women didn't have a vote, which might be, some say, pretty wise. I don't agree with that, of course. Women didn't have a vote, and a black was 2/3 of a person.
Of a human being.
2/3. Right in the Constitution. My. We had to amend that, didn't we? And we had to say, of course, women have a vote. It took a little while. We got, blacks were a whole person before y'all could vote.
That's true.
Took a little while. So obviously the Constitution is not a perfect thing, but you amend it. The amendment process has been amended 27 times. At least that many. But are we to take it in light of what they knew at that time? I say absolutely unqualifiedly not. Absolutely unqualifiedly not.
Or it wouldn't be functional.
No, I took an oath to support the Constitution as I have the light to see with the knowledge that I have and the brains that God's given me, what it means. Not what it meant to them 200 years ago, but what it means now in the real world, because it's a living document. It's a living, breathing document, not some dead words on paper.
And it was written in response to wrongs that were occurring at the time. The quartering of troops, or the not being able to bear arms, or it addressed, at the time it was written, it addressed many of the problems that we were facing here. But in the same regard, it's such a broader document that it's amazing that it can...
If you go back to the history of it, they wrote the Constitution and they sent it out to the states. And what occurred when it went out to the constitutional conventions in the various states? Wow, this almost uniformity of response by saying, hey, wait a minute. We don't have a provision for, and fill in the blank. And how many of the states said we will ratify with the understanding that these things will be corrected and we will have added to them very shortly these assurances, which we now so proudly call, and rightly should, the Bill of Rights. Because our people now who are out there said, I know y'all been struggling with setting up a government, but what about, wait a minute, what about us? And then so what do you have? The First Amendment has what in it? God Almighty, 4 guarantees, meaningful guarantees. And the Second Amendment that you hear so much about because of the guns, and the Third Amendment, and the Fourth Amendment, and the Fifth, right on up to the 10th, right up to the 10th, saying there ain't no right that ain't given here retained by the people and by the states. But all was all at the same time, and how quickly we put those first 10 amendments on there. We put them immediately within a matter of a year or two. They were part of that Constitution, and the people, when they ratified it, and many of them said we'll ratify it subject to us being assured that this is going to be done, and it was done. And I see how quickly they amended, and I say amended, how they improved upon and expanded it to give it life. I mean, meaning. God, you bet they did.
It'd be interesting to see how it would be written today if it were written for the first time.
Well, wouldn't it, though? Be 260 Bill of Rights members.
Oh, goodness.
Articles to the Bill of Rights.
And I don't think it would be as succinctly written either. They don't have Miss Tebow. Let's talk for a moment about the court as it is today. How influential do you feel the Fifth Circuit is in relation to public policy?
Not nearly as influential as it was in years past. But that's a function of several reasons. The times, the matters that are being brought to us, and I also have to factor in the attitude of the majority of the court.
Has the court taken a particular direction since
I think it's
you were sworn in?
I think it's become far more, quote, conservative, whatever conservative means. Not prepared to reach out, as that court did when they took Brown versus Bowen and that which followed, and in the ensuing years, and reached out and did what they saw had to be done.
Do you have any words of wisdom you'd like to leave for future circuit judges, those who will follow behind you?
Wow. Words of wisdom for future judges. Boy, oh boy, oh boy. I could give them plenty of words of wisdom, but they'll think I was being a smart aleck if I said it. Be prepared to come on to the court, and many of the things you're going to be required to do are going to be very simple, and you're going to say back of the hand. But also know that on more than a few occasions, you can be confronted with problems that just simply have no easy solution. And when you reach those, be grateful that you have an opportunity to do this, and bring your best talents to bear in terms of not just resolving that dispute that's on paper in front of you, which you must do and which is your first charge, but also in terms of what you would want to have for your children and your children's children and the next generation that are going to be here and are going to be subject to it.
Think broader than the instant issue, controversy.
Absolutely.
What is your conception of the judge's role in society today? Do you feel they're
problem solvers, which has always been the role of dispute resolution, but also bringing to society a stability and a certainty. People, the highest compliment that can be paid to the courts is for people when they're having a dispute say, listen, I'm taking this to court. And you say, well, that's not a compliment. Oh, that's a compliment of the highest order. We have two or more citizens, maybe not citizens, two or more citizens who have a dispute that they can't resolve, and either or both of them say, "We'll get this resolved. We'll take it to the court." What a compliment. What a compliment when they stop saying that, when they're going to say, "Let's get our guns and go out there and
Then
take
we're
it."
in trouble.
Yeah, exactly right.
Exactly right. How has being a member of the Fifth Circuit changed you personally?
Couldn't buy all the nice things I was going to buy. I still haven't gotten back.
But you're
to
not materialistic, so it shouldn't matter.
I really didn't. We were talking about this the other day. I still haven't gotten back to the salary that I had, the earnings that I had
When you were sworn in?
when I was sworn in. My $1979 in 1979 numbers exceeded my 2001 pay. God almighty. And that's unfortunate, but I'm not complaining, because I could always quit and go back to it. But they ought to, the reality, and it's not a popular thing, but we ought to make sure we don't reach a point where the only people who can accept the judicial appointment are those who are otherwise independently wealthy, or who are willing to have their family sacrificed. There's something troublesome about that.
Well, it certainly limits the pool of
Sure it
applicants.
does. Sure it does. You said to someone, "Come and be a judge," and said, "Well, am I going to be paid?" And he said, "God, that's a third of what I'm making now," and that's what it was when I came on. It was just under a third of what I'd earned that year. That's a lawyer.
But still, you made the decision. There must have been a reason.
Yeah.
I know in the middle, in reading a little bit about your the investigation and the process that you went through before being confirmed, you said at one point it struck you that, hey, I do want to be a judge.
Yeah. That was when we were going through that process. The first time around, when we knew that seat was going to belong to Rubens, and we just knew that.
It wasn't real at that point.
Oh, yeah. It was I was able to say, hey, I was considered for the Fifth Circuit. I mean, get some mileage out of it, you see.
It was a feather at that point.
Oh, yes, indeed. There had been no thought of ever going to court. But then 6 months later, when they created those 11 new slots and they got back at it and said, "We want to consider your name," I said, "Oh, damn, this is serious now." But then got to thinking about, well, what do you want to do? Because at that time I was 20 years plus into the practice. And I was enjoying the trial practice, I have to say that. I did, as much as I fussed about some things. I said, well, and thinking about what is the practice of law, what is lawyering, what is judging, and looking at what the Fifth Circuit had been doing since I'd gotten out of school in '59. It's incredible what they'd done in that 20-year period, and saying, well, gosh, sacrifice, yes, the family, and it impacted seriously on the family.
With 11 children, it had to.
I had 11 children. And it weighed heavily on me. I walked in the dark thinking about this, saying, can I really do this? And but said, well, what do I want to do with the remaining years that I have? And it said, I think I'll go be a judge, not just on any court, a judge on the United States Court of Appeals of the Fifth Circuit. I passed up on several occasions being considered for the trial bench, including in that same time period. One had a vacancy on the district bench here. Thank you, no. But not the Fifth Circuit. That was a different horse. And so rightly or wrongly, I made the decision to come here.
Well, and you say it weighed heavily on you and your family, and a lot of sacrifice. But as you said, if you're a good judge, then you're doing good for your children and your grandchildren in your decisions.
Hopefully.
Yeah. So.
Well, hopefully. And hopefully they'll stay out of jail.
I don't think any of yours have been there yet.
Not yet.
I'd have to look at your little ones.
Some came close. They were too scared of Daddy.
In fact, you've got a parole agent on your hands, don't you? When people look back, people who know you well, who care about you and love you, what would be the most flattering way they could remember you? Is there anything that comes to mind, any particular quality of it? If Judge King or Judge Reevely or Judge Smith said, this is what I remember most about Judge Henry Politz?
I'm not so sure of what fellow judges would say, other than
How would you like them?
I'd like them to say that he decided each case on the basis of the facts of that case and the law as it should be applicable and constitutional provision applicable to that case. I'd like people to say he acted with every matter that came before him and tried to reach a fair and just result for the people that he had before him.
And you thought beyond the instant case.
Without consideration of who they were or what, but a fair and just result. I'd like people to think that, whether I agree with him or not, if they would say, well, he was trying to be fair.